Since the advent of Nigeria's 26-year democracy, the Independent National Electoral Commission (INEC) and the National Assembly have reformed electoral laws and regulations designed to address the flaws experienced in previous elections. Electoral reforms are carried out with the belief that a new electoral legal framework will address the problem of election manipulation, electoral impunity, operational inefficiency, and weak democratic institutions plugging Nigeria's electoral process. The Constitution of the Federal Republic of Nigeria 1999 as amended, the Electoral Act as amended, and the Independent National Electoral Commission (INEC) rules and regulations constitute the legal framework which regulate Nigeria's electoral process. However, breaches or violations of some of these provisions often attract penalties, which on conviction may be a fine, a term of imprisonment, or both. Any conduct, action, or inaction which is prohibited by the Constitution or the Electoral Act and a breach of what attracts punishment is called an electoral offence. Of recent, one electoral issue that has continued to generate discourse is the process of recalling a legislator in Nigeria, as the Constitution makes provision for the recall of members of the National Assembly and State Houses of Assembly in Section 69 and 110 respectively. Implementation, however, is where the problem lies, and there has not been a single case since 1999, 26 years and counting, where a legislator has successfully been recalled under the Constitution. The recall process in Nigeria can be segmented into three main parts: submission of a petition signed by more than 50% of registered voters in the legislator's constituency, verification of the signature by INEC, and the conduct of a referendum. How effective has electoral reforms been in Nigeria? Do electoral breaches or violations attract the necessary penalty? What is the process of recalling a legislator in Nigeria? These and more will form basis of discussion on Good Morning Nigeria.